I want to talk about the timeline of a divorce. Now, every divorce is unique, but there are some basic step-by-steps for every divorce that we can follow and that you can follow to make your process easier, less contentious, less adversarial, less stressful. I can't ever promise no stress. I can't ever promise no adversarial anything on this. You are in a court. You are dissolving a marriage. Many times you are dividing assets. Many times you're fighting about parenting time for your kids. These are the most important things in your world. There are going to be some fights, but by going through a timeline of events and following the process, you can make things a little bit easier than they otherwise would be. We start here, hopefully, with preparation. Obviously, if you've already had a filing against you, you're going to have to rush this step a little bit. But in general, you're going to want consultation. You're going to want to consult with an experienced divorce attorney. You're going to want to consult with your own CPA, your own accountant, if you have that. You want to get a snapshot of your own assets, debts, income, expenses, your partner's assets, debts, income, expenses. Try to get an idea of what are the things that we are going to have to divide. That could be bank accounts, that could be cars, that could be houses, that could be retirement accounts, that could be stocks. All of the things that you've accumulated that you are now going to have to think about. How are we going to divide these out? Think about where you're going to live, where they're going to live, what schools you're going to want your kids to go to, what time you want between each of you. And it's okay if you don't have an immediate answer, but the more you think about these things, the more you talk about these things, the more you have an idea of what you want before we even file anything, you're going to have a smoother time. You're going to have an easier time getting to that resolution that you want. The first thing that happens after you have all that preparation is someone files. If you're doing a dissolution, it's both of you. Both of you are filing. But most of the time, it's not that. Most of the time, one of you is going to be filing. Either spouse can file. It's just a complaint. It's filed in the county that you live in, domestic relations court. That is served on the other side. They then file an answer and a counterclaim. You're just saying, court, we want a divorce, and these are the grounds that we want a divorce. In Ohio, most of the time, that is incompatibility. That's a no-fault divorce, just saying we no longer believe that we can compatibly live together, that we can parent together, that we maintain in a marriage. A lot of that initial filing, that complaint, is just forms. It's just a statement of your assets, debts, incomes, expenses. Most courts have their own local forms, but otherwise we're using the ones from the Ohio Supreme Court to give the court and the other side a snapshot of what it is that we are dividing. In addition, it is extremely common for us to file at the same time temporary orders. We want to maintain something. We want to maintain a portion of this relationship. Usually that is parenting orders. Usually that is, we want parenting time to be X, and we want that parenting time to be X throughout the pendency of this divorce proceeding, right? These are quick hearings. They come in, the courts want to rule on them fast, to get something in place to reduce disputes, reduce constant motion practice on this down the road while we're dividing everything out. The other thing that we will sometimes do, particularly if we have one higher earning spouse, one lower earning spouse, is we'll want temporary support. That can be temporary spousal support to maintain a standard of living for the lower earning spouse. That can be temporary child support, which is almost file court every single time that we file one of these divorces from either side, to get some kind of support going from one spouse to the other to make sure that the kids are being taken care of. That's the absolute priority here. Many times those temporary orders, we don't even have a hearing. The court takes them, looks at them, talks to the attorneys, and makes an order. And really, we only have a hearing after that if one of the parties asks for it after that. These are designed to be quick. After we do our temporary orders, after we do our complaint, the longest period of any divorce litigation is our discovery phase. That is when, after looking at these first initial documents of assets, debts, income, expenses, we say, okay, but we aren't sure that's the whole picture. So we're going to ask you, the other side, to give us things. Give us bank statements, give us tax records, give us account statements for your retirement accounts for life insurance, sufficient cash value, or anything that could be an asset or a debt or income or something. This is usually the exchange of documents. Sometimes it can be depositions between people. If someone is alleging abuse or infidelity or something like that, this can be third-party subpoenas. If one of the spouses has an interest in a business, which happens quite frequently, this can be involving that business intimately, freezing the assets there sometimes of that business and bringing them into the case. Once you have gotten through that discovery phase, we try to resolve these cases through either an informal negotiation, back and forth, or a more formalized mediation. Most courts now will have a mediator that will attempt to resolve one or more of these issues. And there's a lot of flexibility here. You can do this without attorneys, you can do this with attorneys, you can meet all in the same room, you can go back and forth. The goal is to try to reduce the scope of the dispute. Are there things that we can agree on so that if we do have to go to trial here, we're only trying one or two things? That reduces time, that reduces expense, and that reduces stress on everyone. If mediation fails, settlement fails, then we go to trial. We try to avoid this if possible, but sometimes you can't avoid it. And part of the reason we try to avoid it is because even more than that discovery, this is the most time-intensive, the most expensive, the most stressful portion of any divorce. You're going to have to testify. People you know and love are going to have to testify. We're going to have to cross-examine your spouse. And it's about things that no one wants to talk about. It's about money. It's about how much you make. It's about what your assets are. It's about maybe someone's hiding something, and now we have to get into that. It's about how each of you treat your kids. It's in the history that we go into there. It's all of the worst parts of a person's personal life that we're going to put on public record. That trial, it's very simple, 1 to 2 days. Sometimes these can go weeks. Sometimes these can go months, depending on how complicated this trial is, which is part of the reason why we try to resolve as much as we can, as fast as we can, before we get to that point. At the end of the trial, absent very, very, very limited circumstances, there will be a divorce. But it might not be the divorce that you wanted, or that the other spouse wanted. There's going to be a division of assets, debts, income, expenses. There's going to be an order of support, and saying support is necessary or support is not necessary, for how long and how much it's going to be. And there's going to be a parenting order, whether it's shared parenting, whether that's custody, and what the parenting time is going to be. In Ohio, many of our trials are heard by a magistrate, and if that's the case, then you have a very, very, very brief period of time. You got 14 days from that date of the decision to file an objection to that. And if you don't do that, it is possible to overturn that, but extremely difficult. So vanishing on 1%, 0% to actually overturn that. After you file those objections, if that is adopted by the court, you got 30 days to file a notice of appeal if there's an appealable issue, if you want to fight about something else. And that's a whole other period of time where now you're still going by whatever those temporary orders were down at the lower court, and you're fighting in the Court of Appeals about all these things. And you might win, and that just means you go back down to the lower court to retry one or more of those issues, or you might lose. And now that is the order as it is. In general, we are supposed to handle these things in a year, from front to back, beginning of the complaint to an actual trial. We try to get these done well before that, if possible, but that year, even though it's supposed to be a hard deadline, is often extended, usually because of discovery disputes, but it can be for other things, just for scheduling, for et cetera, et cetera. You should have that in the back of your mind for all of this, is that if we can't resolve this suit, if I can't get all of my information to my attorney, they can't get all their information to their attorney, we can't resolve this, you're looking at least a year fighting with your ex about your money and about your kids. That's your timeline. If you have questions about that, if you would like more information, or you're trying to get a better handle on what your options are, please feel free to give our office a call.